This is Ronnie O'Neal. He is a double murder suspect in Riverview,
I've actually seen
Florida.
this on Instagram.
I'm here to play around with y'all. God damn it on that.
O'Neal was 20.
So that, I think probably everybody that has an Instagram account has probably seen that. Yeah, he's a lunatic. He's trying to intimidate everybody, to include the judge.
O'Neal was 29 when he fatally shot his then-girlfriend Kenyatta Barron. Following this, he murdered their own daughter by striking her multiple times with a hatchet. She was only 9 years old. O'Neal also stabbed their 8-year-old son before pouring gasoline all over the house and setting it on fire.
So, you know, you hear this, again, kind of back to my other point, you're like, what are we doing here? Like, this is so obvious, this guy's so deranged, like, we're gonna have this guy parade around in court. Again, the strength and the weakness of the system, mostly the strength, is that this guy gets his day in court. And he may not have even a colorable argument that he didn't do it. Nonetheless, he's entitled to a jury by his peers.
O'Neal was arrested upon fleeing the burning house. The son was able to escape, but was critically wounded and suffered from burns. The first 911 call on the incident was from the girlfriend, who was heard screaming before suddenly hanging up. 8 minutes later, another call came in from O'Neal.
911, what is your emergency?
Hey, I just been attacked by some white demons. Inside Kiki.
So, yep, right here you got clear signs that he's got some sort of mental illness, claiming that, you know, demons inside. Some states, not all states, but some states have some version of a not guilty plea by way of insanity. Colorado's is different than Montana's. Sometimes it's before trial, sometimes it's after trial, but it looks like he's going to be representing himself, so he may not even be aware that he could claim that as a defense, but we'll see.
Kiki, her name is Kiki, and she tried to kill me.
What's she at?
Huh?
After the arrest, O'Neal was psychologically cleared to represent himself in court. During the trial, he cross-examined his now 11-year-old son, who he stabbed, to which the son...
I mean, that's crazy to me that you've got the person that is responsible for the harms gets to cross-examine him. I would assume that they probably put in some sort of a mechanism to get this kid at least in a place where he can be comfortable to testify. In any trial, you're always worried about witnesses that either are overwhelmed by the situation or they decide that once they get to the witness stand, they're going to say something different than they've told you before. That's going to be compounded where you've got an 11-year-old kid where his victimizer is the one asking the question. So my hope here is, and we'll find out, is that the prosecution puts something in place to protect this little kid.
Explained everything that happened.
It's good to see you, man.
Good to see you too.
Did I hurt you that night of this incident?
Yes.
I did.
So again, like back to like really interesting legal analysis here. So this is considered a cross-examination. So there's two types of examinations. There's direct examinations. Those are typically your witnesses. When I say your, if you're the plaintiff or the defendant. The rules of evidence allow you to only ask open-ended questions. So in a question that he just asked is an open-ended question. When you're cross-examining questions, you never ask a question that, number one, you don't already know the answer to, and you lead them down the path you want them to go. So as an example, in this case, if he truly was going to ask a cross-examination question, he would have framed it like, I didn't hurt you that night, did I? If he was my client, I would have said, Mr. Jones didn't hurt you that night, did he? And that way you're providing the answer to them. But you saw in that it was an open-ended question, did I hurt you that night? That's an open-ended question, and it got put right back in his face. Thankfully, this little kid says yes.
And how did I hurt you?
You stabbed me.
O'Neal also accused the prosecution of fabricating evidence.
Because he's playing a fraudulent damn recording of me beating Kenyatta Barron. I did kill Kenyatta Barron.
After O'Neal was found guilty at his sentencing, the judge went on to say this was the worst case she's ever seen.
So right then, totally inappropriate way to go about obviously yelling and stuff is way out of bounds, but he's arguing the case. Now, there's only one time where a lawyer can actually argue the case, and it's at the very end during closing argument. Up until that point, you can't say things like they played a fake recording. So evidence only comes through one place, and it's the witness stand, whether it's a witness giving testimony or somebody entering in physical evidence, like, isn't this the knife? Those types of things. What he's doing right there, where he's just screaming that there's somebody played a fake recording, was probably not done in closing argument. And that's the only time that you'd be able to put that evidence together, if that was true, to argue that somebody had a fake recording. I don't think that's when that occurred, but again, just kind of the pitfalls of representing yourself.
This is the worst case ever in my life, and I have seen some horrors.
He also stated that he was not sorry for what he did.
I am not sorry for something I didn't do, and I am not sorry for the things I did do.
O'Neal was given a total of 3 life sentences plus 90 years without parole. And for O'Neal's son, he was adopted by the detective who cared for him the night of the murders.
Yeah, so I guess I would just round that out by saying anytime you get somebody that far gone and mentally ill, really difficult to control their courtroom behavior. And certainly, the judge there at the end kind of lecturing. It's not often that you get judges doing that. I think that's rare that they would give kind of their personal insight on something like that. But I think in a case like this, where somebody is convicted and the jury has obviously been unanimous about that, I think the judge felt like she had some leeway to do that. It's not often you hear judges say or do that, but certainly in this case it was probably warranted. Anytime somebody is standing trial like this person is, the judge has to make a determination as to whether or not they have the mental faculties to actually know what's occurring to them in the courtroom. And that sort of goes to whether or not they would have had that same sort of culpability when they committed the crime. So the claim of insanity, while it seems strange, means that the person doesn't even know what they're doing is wrong. So when it comes to these, demons overtook somebody and that type of thing, you heard earlier in that video that there had to be a determination to see if that person was even able to stand trial, meaning did they even know what they did was a crime? And strangely, if you can prove somebody is so crazy they didn't even know what they were doing was a crime, then that's when they usually get successful insanity pleas. So again, different states handle it different ways. As an example, Montana would say, okay, yeah, you're crazy and you didn't know what you're doing. We'll handle that post-trial where it comes into sentencing. A lot of these folks end up in hospitals and mental hospitals and that sort of thing if they actually are truly not capable of understanding the wrongs of their acts. The judge in this case determined that he did. You heard him mention during his closing argument, I think it was, that he admits to killing one person or another without justification. So to round that out, no religion can justify murder. The only thing that this person would have probably been able to argue was that he was criminally insane, didn't know what he was doing was wrong.